right, you may be seated. Thank you. We have our third case this morning, 21-2078. Thomas, is it Damas versus State Farm.
Good morning. May it please the Court, George Vaca from Vaca Law Group on behalf of Mr. and Mrs. Damasi. With the Court's indulgence, I'd like to reserve 5 minutes for rebuttal, please. We're here today to ask this Court to reverse a summary judgment that was entered against Mr. and Mrs. Damasi concerning their bad faith, first-party bad faith case that they had asserted against State Farm. And I think, and then also to remand the case back to the trial court for a trial on the merits. The relevant facts in this case are not disputed, and I think I'm going to talk about them only because I think all cases, but especially this one, need to be read in the context of the facts. So in October of 2009, Mr. and Mrs. Damasi observe a sinkhole loss at their Weeki Wachee home, and they timely report it to State Farm. State Farm retains as its expert geohazards to conduct a geotechnical investigation into the case, or into the cause of loss. On March 19th of 2010, Geohazards issues its first report acknowledging that there is sinkhole activity that was occurring on the property and it was damaging the property at that time. It recommended chemical and compaction grouting as the ways to repair the structure, and the Damasis permitted them to do the repairs as recommended. Fast forward to October of 2011. Geohazards comes back out to the Damasi residence to review additional damage that has taken place to the Damasi home. Geohazards again concludes that the damage is caused by sinkhole and recommends additional grouting. The Damasis once again permit that recommendation to go forward and be implemented. With the house still deteriorating in August of 2012, now almost 4 years after the claim has been submitted, Damasis and the State Farm go to neutral evaluation, which was part of the statute back in the under old sinkhole statute. And the neutral evaluator concludes that there's still sinkhole activity going on and that it needs to be repaired. What does State Farm do? In response to the Damasis demanding that their house be repaired or they've been paid the policy limits, State Farm sets them for an EUO, demands documentation, demands all sorts of things from them, which they comply with. They complied with every one. State Farm never disputed that. Then in April of 2013, State Farm hires a different engineering expert firm called, I believe it's MTC, who then concludes, MCD, who concludes that there's no sinkhole activity at all going on. At this point, the clients are asking State Farm, can you reconcile the inconsistencies in these reports? This is our home. It's clearly damaged. Tell us how to fix it. And State Farm doesn't do any of that. At this point, the home's not repaired at all. State Farm didn't pay the limits. State Farm attempted to use the repair methods that its subcontractors decided were good and then abandoned the effort. And when they persisted and they were told they had to sit for the EUOs and all the other stuff, eventually they filed this civil remedies notice nearly 5 years after the date of loss on August 27th of 2014. Ultimately, in 2015, after the civil remedies notice expires, State Farm concedes that the house cannot be repaired and pays the policy limits to Mr. and Mrs. Damasi. This lawsuit then follows. State Farm files a motion to dismiss, which is granted by this trial judge on the basis that we can't go forward because there hasn't been a determination of liability by way of a breach of contract action. That case comes up to this court. This court disagrees with the judge on that, and says, no, there's been a determination of damage, that's all you need for this. You've timely filed the notice of the civil remedies notice. You've done all you're supposed to do. This case can proceed. And so the court reverses that judgment. Its mandate issues in 2018. We go to 2019, when State Farm finally gets around to answering this case. And for the first time in its second affirmative defense, it challenges something about the sufficiency of the CRN. Now, mind you, the CRN had been filed 5 years before that. And they had a motion to dismiss that they had raised where they didn't raise any of this issue. And I wanted to point out to the court, I don't know if the court has gone back, but this answer in defenses has something a little bit unusual to it. And this is at page 681 of the record. It almost has an introduction to the affirmative defenses. And it says, if an affirmative defense below is more appropriately a denial, then State Farm Insurance Company will defend accordingly. State Farm Florida Insurance Company does not intend to assume or shift the burden of proof on a denial by raising an affirmative defense. Also, State Farm Florida Insurance Company reserves the right to supplement or to add any additional affirmative defenses. Now, that's going to be at least important to my argument for one reason. The second affirmative defense, the second defense that they identify as an affirmative defense is not an affirmative defense. It's an element of my cause of action that I have to plead and prove. And according to Trawick, that's not an affirmative defense. According to the case law out of this court, that's not an affirmative defense. An affirmative defense is, yes, I admit everything you say, but I can avoid it because of some legal justification. That's not what this is about. This is an element of my case.
Do you think that need is obviated, the proving an element of your case is obviated by virtue of the fact that it's raised as an affirmative defense?
No.
Okay.
No. And I'm going to get to that. That's the second part of my argument, so if you'll just bear with me for a minute. Because I want to walk the court through. I know the court's looked at the CRN. And ultimately, the judge here rules, based upon their motion for summary judgment in this case, that the CRN is insufficiently specific. Therefore, it's defective and insufficient for us to go forward on our case and grant summary judgment. But the civil remedies notice at page 1 identifies who the complainant is, it identifies who the insured is, it identifies who the attorney is, it identifies who the insurance company is, and it identifies each of the known representatives of the company who have participated in this claim to the best of Mr. and Mrs. DeMasi's knowledge. There's, I believe, 4 people identified. If you go to the next page, it says reason for notice, claim delay, failure to pay claim in full, failure to properly investigate claim, failure to adjust loss, and failure to perform proper testing. And then there starts to be a listing of statutory violations. Now let me...
So getting to this aspect of the CRN, do we need to accept your argument that we should construe the statute liberally in order to find that these aspects of the CRN are stated with specificity?
I think you can construe the statute strictly, the words of the statute, as was said in the Pin-Pon decision, or in the other decision out of federal court out of the Northern District. I can always struggle with the pronunciation of the case, but it's one involving, I think it's apostolic church. Mm-hmm. The analysis there is, yes, you construe the words of the statute strictly because it's in derogation of the common law, but you don't confuse strict construction with strict compliance.
Okay. And so then, second question, same question, will we need to accept your argument on substantial compliance in order to find that the CRN meets the requirements of the statute?
In my view, no. Even if you apply strict compliance, because everything in this case has been based upon the 4th District's decision in Julian, and a bunch of district court cases from federal court that have been addressing this case or this issue occasionally over the years. It's only really recently, until Julian in 2021, that any of the DCAs in Florida have really taken this issue up and addressed it. And as we put in the brief, and this is where I think the Julian court went way wrong, okay, is if you look at the statute says, any person may bring a civil action against an insurer when such person is damaged, and then it goes to, that's subsection 1, then it goes to 1A, then you go to 1B, by the commission of any of the following acts by the insurer, not attempting in good faith to settle claims when under all the circumstances it could and should have done so had it acted honestly and fairly towards its insured with due regard for the insured's interest, okay? That specific violation is one that is alleged in this specific CRN. Then you go to 3A, okay, which is the statute that deals with what you have to do with the CRN, okay? And it says, as a condition proceeding to bring an action under this section, the department and the authorized insurer must have been given 60 days written notice of the violation. The violation. Notice to the authorized insurer must be provided to the department by email address, blah, 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 blah. The notice, then the next one, the notice shall be on a form provided by the department and shall state with specificity the following information. Excuse me. I wanted to point out that the form provided by the department requires you to list all statutory violations. The statute does not. The statute references the statutory violation. Why is that important? Coming back to my criticism of the 4th District, if all we're looking at is whether or not this CRN is sufficient for the violation, the 624-155-1B1 absolutely clearly stands. You can question all the other ones if you want, but that one undeniably should withstand appeal. You go down to the language through the statute, okay? 2, the facts and circumstances that giving rise to the violation. 3, the name of any individual involved in the violation. 4, reference to specific policy language that is relevant to the violation. So it's my position that even if the court strictly construes this statute, you have to look at the statute, each violation independently, and see if the CRN appropriately provides the information required for that violation. And if it does, the remedy is not to throw the baby out with the bathwater if 5 of the 6 that are alleged are insufficient. The answer should be there's one that's sufficient, that's the one that stands. Because we've complied with the statute as it pertains to that.
So the argument would be that we don't need to look at the CRN holistically, and the fact that it lists, several statutes, several rules, all these aspects of the insurance policy, that given notice is sufficient if there's a sentence or two that we could pull out that satisfies.
Well, in going through this civil remedies notice, so yes, there's identification of different parts of the policy, but then there's the narrative part of this civil remedies notice that I don't think that the court can overlook. So it says to enable, and this is, page A8 of their appendix, or page 83 of the record. So they list a bunch of different provisions in the policy. Then they start the narrative, right? Failure to pay claim, failure to properly investigate, failure to properly investigate, a whole bunch of things. Okay? Then if you go down to the 3rd paragraph, last sentence, State Farm has refused to acknowledge and pay the full amount of its insured's claim. Go down to one additional paragraph, the one that starts on or about October 30, where they then recite the undisputed facts of the claim's handling of the case. None of this part of it is at all disputed. Okay, then we go to the following page and we go to the 7th paragraph. Mr. and Mrs. DeMasi were and are still forced to expend out-of-pocket monies to mitigate their damages. State Farm must honor its obligations under the insurance policy and pay all the insurance proceeds due and owing. Next paragraph. State Farm has refused and/or failed to comply with the policy's cooperation and/or lost payment provision. So they're telling me exactly where in the policy they have violated the...
How? I mean, that's
Because
the
they haven't paid the
specificity, right?
benefits that were due.
But how did they fail to comply? So if you have not paid benefits, you have failed to comply with the policy. That should be specific
When
enough.
you've been provided with information for over 5 years on adjusting the claim,
So that specificity is missing then, right?
no.
Okay.
No, we've pointed out in this civil remedies notice, the 5-year history that precedes the filing of this notice, this civil remedies notice. They've had all these tests. They've had 3 or 4 engineers tell them that this is all caused by sinkhole activity, yet they refuse to pay, and they refuse to fully repair, and then they refuse to admit that it can't be repaired and pay the policy limits. That's what this says. And so at least as to the 624, 155, 1B1 assertion that you didn't pay my claim, this statutory notice is absolutely sufficient because it says, we put you on notice.
What case do you think best supports that proposition that this is sufficiently specific?
How about the Apex case out of this court? The Zaleski case out of the 4th DCA. Both of those are civil remedies notice cases where the court says generally you put them on notice, they didn't pay, and that was in and of itself sufficient.
You're into your rebuttal time. I mean, don't...
Yeah, I'm going to, let me just...
You can use your time as you wish.
Thank you, sir. In the Apex roofing case that came out of this court July 1st of this year, and rehearing was denied in August, the court said, looking at Zaleski, the 4th District Court reversed in analyzing the allegations in the CRN that, among other things, the insurer performed a cursory inspection, gave a lowball estimate that failed to encompass all damages, failed to retain the necessary experts to identify the repair work needed to restore the property to its pre-loss condition, which is in fact alleged in our CRN, had been provided a detailed estimate and the cost of repair, and the 4th DCA held that that CRN had sufficiently placed the insurer on notice of the specific facts and circumstances giving rise to the violation. And this court adopted that part of the decision as its own, agreeing with the sister court of the 4th DCA on that case. So I'm going to try to save my last 3 minutes for rebuttal, but the only other point I wanted to make with respect to the waiver argument was we were not required to state a reply to this affirmative defense that's not an affirmative defense. And so the waiver argument, which arises out of the Evergreen case and the Carla Bay case out of the 4th DCA, does apply. It was made, and it was error for the judge to deny it based upon the fact that we didn't plead a reply to an affirmative defense that didn't exist.
May it please the court?
Yes.
My name is Ezekiel Lugo, and I represent the appellee State Farm Florida Insurance Company. We request that the court affirm the trial court's grant of summary judgment for 2 main reasons. First, the civil remedy notice in this case did not comply, whether strictly or substantially, with the specificity requirement of Section 624.155, subsection 3. The second reason is that the arguments about waiver were not preserved in the trial court, were not preserved on appeal, and even if they had been preserved, they fail on the merits. Turning to the first argument regarding compliance with the specificity requirement, the case on point here is the Julian Decision out of the 4th District Court of Appeal. That was the only case in the state of Florida that addressed an almost identical CRN filed by the same attorney that filed the CRN in this case, that had the same deficiencies as the CRN in this case. It was the only case in the state. It was binding in the trial court. In that case, in Julian, the CRN asserted had 2 main problems. One was that it did not cite the specific policy language, and the other one was that it didn't cite the specific statutory provisions. As to the policy language, the CRN in Julian, towards the end, it included something that looked like a table of contents of the provisions that are usually found in property insurance policies. I started with coverage A, coverage B, coverage C, listed several provisions, and then towards the end it had two catch-all provisions, one for all insurance policy provisions that provide coverage to the insured property, and the last one for all policy provisions. The CRN in this case matched that almost entirely. The main difference is that maybe it didn't include the reference to coverage B and coverage C, but it did have those catch-all provisions at the end. That's a problem because, as the 4th District recognized in Julian, listing nearly all the policy provisions on the notice doesn't satisfy the statute. And
It's too much information. Is that what destroys the specificity?
Yes, Judge Edwards, and that is because of a portion of the statute that I did not hear Mr. Vaca address. And yes, it is a notice statute, but it has substantive consequences, and that's important. The court needs to look at subsection 3D of the statute. That says, no action shall lie if, within 60 days after filing the notice, the damages are paid or the circumstances given rise to the violation are corrected. The relevant policy provision and the relevant statutes are necessary, and they are important because they alert the insurance company as to what it is that it has to correct to effect a cure under the statute that would then bar the cause of action. If the CRN includes policy provisions that are not applicable or that are not addressed in the facts and circumstances portion of the CRN, it makes it difficult, if not impossible, for the carrier to cure.
Do we have to presume that the carrier knows nothing about the claim other than what's in the CRN?
No, Your Honor. The carrier knows some things, but there may be allegations in the CRN. And for example, in this case, part of the problem with the statutory language is that it cited 15 statutes and 22 regulations. Some of those regulations included, for example, an allegation that the adjuster had been dissuading the insureds from seeking legal advice. There may be some communications that are reflected in the carrier's internal materials, but if there was, for example, a verbal communication where that statement was made, the carrier may not be able to figure that out from its internal documentary evidence of the case. And if specific facts regarding such an allegation are not included in the CRN, it does not allow the carrier to take the effects to reach out to that adjuster and correct the situation.
What do you say to What do you say to the appellant's argument that if we got it right with one, just one, there's page after page, statute after statute, claim after claim, but if we're good on one, you can't dismiss the case, you can't grant summary judgment for State Farm, throw out everything we weren't good on, but the one that was good, we get to go to trial on. How do you respond to that?
First response is there's nothing in the statute allowing severability of the claims that are asserted in the CRN. The next
if they had only put one, what, instead of putting all, if they just put one, the one thing that Mr. Vaca says they got right and did properly and get a gold star for that one, if that was the only thing there, they could go on that. They don't have to necessarily, under the statute, state every possible insult or injury they had from the insurance company, do they? They go, this is what we're complaining about, this is what we want fixed.
If that's all they did, if the CRN was tailored to the specific facts and it went no further, then that's fine. That's what happened in the Gooden case out of the 4th District Court of Appeal after Julian, where in that case, there was one policy provision that was recited and quoted, and only, I believe, between 8 or 9 statutes that were relevant to the actual violation at issue. But if it goes beyond what's relevant to the claim, to the facts alleged in the CRN, then that is problematic because it affects the carrier's ability to cure the allegations of the CRN. The language of the statute requires, the plain language, the legislature required that the notice has to state with specificity the following information, and that includes the statutory provisions, including the specific language of the statute which the authorized insurer allegedly violated. So if the insurer or the complainant asserts, the entire policy provision, then they're claiming the carrier violated the entire policy. It also requires reference to specific policy language that is relevant to the violation. So if they cite 15 statutes and 22 regulations, they have to tie those to the facts and circumstances of the case so that the carrier is able to analyze that civil remedy notice and take effects, take measures to correct and cure the alleged
So is that your
violations.
argument about what's deficient here is not necessarily the number, but the fact that the number is not tied to the specific facts?
It's together, Your Honor. There are cases saying that CRNs that take, some courts describe it as a kitchen sink approach, other courts describe it as a shotgun blast approach. Such kinds of CRN are invalid and insufficient.
So I guess how do we distinguish the shotgun approach from the CRNs where there truly are 15 statutory violations? What aspect of a CRN would distinguish those two scenarios?
It has to be tied to the allegations in the portion of the civil remedy notice that requires the facts and circumstances given rise to the violation to be addressed. So in this case, the trial court did not err because, like in Julian, the civil remedy notice in this case referenced all policy provisions and all insurance policy provisions and was invalid. It also applied Julian correctly because in this case, there were 15 statutes and 22 regulations. In Julian, there were less, 14 statutes and 21 regulations, and they were not all tied to the facts and circumstances allegedly given rise to the violation. Opposing counsel made the arguments in the brief and made a long portion of it is addressing the substantial compliance argument and the standards set out in the Ping-Pong case. The 4th District did recognize that the Ping-Pong trial court, the federal trial court in that case, had changed its ruling. Initially, it had found 3 technical deficiencies that had to do with the fact that the CRN didn't include the name of the complainant, didn't include the email of the complainant, and didn't include the address for the complainant. Those were technical deficiencies because the statute, the legislature, did not require the CRN to include that information. So initially, the federal trial judge had found the CRN was invalid because it didn't include that additional information that the department required, but was not required by the statute. On rehearing, Ping-Pong changed the ruling, the trial judge changed the ruling, and he set forth a 4-part standard for looking at whether there's been substantial compliance. And part of that standard is that the court is going to overlook a deficiency, first of all, if it addresses a technical defect. Here, we do not have a technical defect. The Julian...
What do you think about the substantial compliance test kind of as an original matter? We're not required to follow district courts, federal district courts or state judges. So to my view, this is a statutory condition precedent. The legislature has required that CRNs be stated with specificity. Are you aware of any cases applying an exception, a kind of a substantial compliance rule to a statutory condition precedent as opposed to a contractual condition precedent, such that kind of substantial compliance is even relevant?
No, Your Honor, I'm not aware any such case exists, and no such case was cited by the appellant, in this case, either in the trial court or in the appellate court. Part of the analysis or the reasoning behind the substantial compliance from the federal courts was reliance on 2 cases. One of them is a case called Prida out of the 3rd District Court of Appeal, where the 3rd District noted that the issue in this case, the notice problem, and it had to do with the font of a portion of an insurance policy, was not something that dealt with a condition precedent. The other reason was that there was no consequence for the violation stated on the statute. So the third district made it clear in that case that this substantial compliance analysis would not have applied if the case involved a condition precedent like the one here. That's part of the reason why the federal courts we submit have veered into erroneous territory by applying the substantial compliance test or analysis in this context.
So wouldn't that be a legislative function then, if there's going to be either a prejudice exception or a substantial compliance exception or a waiver exception, would that need to be a legislative function?
Yes, Your Honor, that would have to be a legislative function. Under the case law that we cited and the courts that have applied strict compliance and strict construction, first one being Talent, where the third district, the Florida Supreme Court analyzed subsection 3, and in interpreting the language of that statute, it held that strict construction applied. And in that case, they did recognize that the statute created a remedy that didn't exist at common law, but it still applied strict construction to the statute. Another case that has applied the strict...
What's your response to the Talent, to that language in Talent as dicta?
It is not dicta, Your Honor, because the whole issue in Talent was whether what sort of damages have to be paid in order for there to be a cure. The case was about what is now subsection 3D, that language, that no action shall lie if within 60 days after filing notice the damages are paid. The claimant in that case, their position was that the damages that had to be paid were the contractual damages plus extra contractual damages, that there could be no cure if the carrier has simply tendered the policy limits. The Florida Supreme Court, in addressing that specific argument, rejected it because it strictly construed the word damages to mean the damages that have to be paid are the damages due under the policy, contractual damages only. If a liberal construction applied, then the complainants would have been correct. But the Florida Supreme Court did not address that. It is not dicta. It was the key issue at play in that case. How is the word, the phrase, the damages are paid to be interpreted? And the reason why, you know, in addition to the fact that this is a legislative issue, the legislature has said, and they included that language there, there's mandatory language there, shall, and the word specific or specificity is included in the statute 4 times. The legislature couldn't have been clearer that as a condition precedent, the complainant shall provide notice on a form provided by the department that includes the information required, the statutory provision that's allegedly violated, the facts and circumstances giving rise to the violation, and reference to specific policy language that is relevant to the violation. If the CRN does not do that, it's not specific to the alleged violations, then the CRN is invalid. It does not comply with the requirements set out by the legislature. And we've cited Florida Supreme Court case law saying that when a person, a party is trying to seek the benefit of a statute that's in derogation of the common law, then that party has to strictly comply with the terms of the statute. Some of the federal courts that have veered away from the strict compliance requirement do not address those cases, do not distinguish those cases. And we cited those in the answer briefs. The Florida Steel case is one of them. And we rely on that, on the briefs for that point. But I want to address the waiver arguments that have been made and some of the positions that have been mentioned today. My opponent started with the argument or the idea that the second affirmative defense is not an affirmative defense but an element of the case. Problem number 1 with that argument is that it was never raised below. The trial judge was never alerted to that argument. It played no part in the trial judge's decision-making process that led to the idea that waiver was not asserted in a reply to the affirmative defense. It was also not raised in the initial brief. In fact, the initial brief does not address the trial judge's specific finding on pages 11, 26, and 27 of the record, where the trial judge ruled that it could not consider the appellant's waiver arguments because they were asserted for the first time in the motion for summary judgment and had not been raised in a reply to the affirmative defense setting out compliance with 624155. And to remind the court, State Farm alleged that the non-compliance with the statute in its first answer as the second affirmative defense. And that's on the record at 681, 682. The appellant, in response to that answer in affirmative defenses, filed a motion to strike several affirmative defenses, 4 or 5 of them. The second affirmative defense was not a target of this motion to strike. If in fact it was an improper affirmative defense, that was the vehicle for them to raise that issue, and they did not do so. After the judge granted that motion to strike in part, an amended answer in affirmative defenses was filed that again raised 624155, and then when the Julian case came out, that affirmative defense was amended to specifically address some of the points from the Julian case. Thereafter, the appellant, if they believe that there were additional facts showing that there had been a waiver or an estoppel in this case, they were required to plead that in a reply to the answer in affirmative defenses. And that's required by multiple cases, including the Gamero case from the 3rd District Court of Appeal. They did not. Trial judge found it was not properly before it for that reason. That argument, the Gamero case, is not addressed in the initial brief. For the first time when this shows up, that non-compliance with the statute is not an affirmative defense is in the reply, and now today at the oral argument, it is too late. That was not preserved on appeal.
I think there was an argument at the end about whether or not there was the sufficient specificity being a factual issue. Do you have a response to that?
Yeah, there was a case from Judge Jordan, I believe, pre-Julian. In 2011, I think you're referring to the Vinny's Restaurant and Lounge case. In that case, Judge Jordan noted that there was no case law addressing, no Florida case law addressing the issue of substantial compliance with the statute. He noted that there was a prior case from this court, the Lane case, where this court seemed to have adopted a trial judge analysis that a CRN was not specific enough and was invalid for that reason. But other than that, it found no guidance as to what constituted substantial compliance and what didn't. That case, our position is that it's now obsolete after Julian. And now
We don't have to accept Julian, though, so why should we determine kind of as an initial matter quickly why this shouldn't be an issue for the jury and why it's appropriate?
Well, it's not an issue for the jury, Your Honor, because there's no dispute about what the CRN states. The CRN states what it states. We know what the legislature required the CRN to state. The case law makes it clear, Florida Supreme Court case law, that if you're trying to seek the benefits of a statute in derogation of the common law, there has to be strict compliance. That case law applies because there's no dispute about the facts, and the case law requires strict compliance. It's not an issue for the jury, something the judge can decide.
All right, thank you.
Thank you, Your Honor.
Just a few minutes. Judge Edwards, I thought I clearly heard you ask my opponent about the argument about if we sufficiently state in the civil remedies notice, we comply as it pertains to any one of those statutes that are listed, whether that would allow us to go forward. And I don't remember hearing an answer to that question. But I want to point out, right, if we filed 35 independent civil remedies notices, all alleging independent one paragraph statutory violations, and they move for summary judgment on all of them, the one on 624, 155, 1B1 would have to be denied because we've absolutely complied with that. The language in the policy is referred to State Farm refused and/or failed to cooperate and/or adjust the loss by cooperating with Mr. and Mrs. DeMasi during the claims adjustment process in compliance with the policy's loss payment provision. This is a breach of the policy. If that's not sufficient to put them on notice, what they're doing is in violation of the policy. I don't know what would do it. And again, as I started out this oral argument, you have to view this case in context. They had 5 years of adjusting going on this case before they ever got a civil remedies notice. And to sit here and argue like we didn't know what was going on is just unrealistic. You know,
Certainly say that about half of the CRN. There's an awful lot of things thrown in there, the kitchen sink, shotgun blast, whatever
I
you
don't
wanna say.
disagree with that. I truly don't disagree with that. But if we pled this, right, if instead of pleading it as one cause of action, and we instead bogged the court down with a 35-count bad faith complaint, individually raising each one of these violations as a separate count, this summary judgment would not stand. And most respectfully, we would ask the court to reverse the summary judgment based upon that analysis. Judge Sasso, you correctly noted you're not bound to follow the fourth DCA. This trial judge was, but this court's not. And I think this court's already, in the Apex case, looked at a similar CRN and said that sufficiently put them on notice for the violation that we're talking about. So to me, rather than throwing the baby out with the bathwater, throwing the entire case out, if on summary judgment their burden, there's no evidence in this case, at least not any admissible evidence, okay, if on their burden on summary judgment, they have to show that we couldn't win on any one of those, that any of these allegations and the facts are insufficient as a matter of law to support all of them, not just some of them.
All right, thank you very much.
Thank you. Thank you for the
Mr.
court's time.
Lugo, Mr. Vaca, very well briefed and argued. We will be in recess.